Greetings, welcome to thctrust.org. We were supposed to have the website up when we say that. This video, we're going back into the commercial crime matrix, and I want to first clarify some things because some of the most intelligent people are the ones who don't understand this. So let me reiterate what the objective or the focus of this commercial crime matrix is. And as I've said from the beginning, the point is to shut down the criminal proceedings by any means necessary. It's nothing that we want to participate in, but most of the time we find ourselves dragged into these situations. So we're trying to get an estoppel. We're trying to make it to where they cannot proceed. We don't want to participate in this contract. I want to reiterate that because some of the most intelligent people here are sending me emails saying, oh, they're not going to honor any of that paperwork in court. And this way of thinking is probably what's preventing you from getting certain remedies. The objective, again, is not for them to honor it in court, right? You don't necessarily need for them to honor it in court for us to get the desired result, which is to shut down the matter, right? So you also have to consider when you're a public officer or whatever, right? Public official. Everything that you're required to do is written in the public record. So when someone presents you with something or requests that you do something that you're required to do, but for whatever private or secret agenda you don't do it, you put that person in a very tight, uncomfortable spot, especially when you learn to stop dealing with fictitious agencies and start dealing with people by name. That's another thing that I want to encourage everybody to do. Maybe I'll come back to that point. But you put them in such a tight position that there's going to come a point where they don't want to proceed because every step that they take further into the matter is further making them incriminate themselves. So there's a lot of thought and a lot of strategy that goes into the presentment of these documents. And I'm going to be honest with you, most of that strategy has nothing to do, really all of the strategy has nothing to do with them acknowledging what you're doing on the public side of the record. It has everything to do with putting them in a position to not proceed any further with the fake matter. So just kind of keep that in mind. And if you have a specific question, right, then ask the question and I'll respond. But so all right. So only thing I'm going to kind of talk about, not one specific document in here, but I want to talk about a little bit. I'm going to talk about the disclosure. Where's it at? Powers of appointment. Request for discovery and full disclosure. Right? So now, obviously we can't go here because you have to be a premium subscriber to access this part of the website, and then you access it from under here, this little premium link. So let's click on that right quick. I'm going to scroll down to the discovery and this full disclosure. And I'm not going to go through this whole document. This is just this is a court like template, whatever, for discovery and full disclosure. And one thing that I want you to realize is that this is also a study tool because these are the things that they're supposed to have. So when you're preparing yourself to deal with these matters, you can go read through this yourself. If you just have to do things in real time, these are the things that they need in order to be a legitimate court. Where's your delegation of authority order, right? That's one of the things you might ask for. You may ask for the name, the nationality of the injured party, right? And of everybody in that matter, especially if you're Moor or you're indigenous. Why is it relevant? Well, one, because there's been a lot of slavery and different things going on in this country, and it's still going on. So you want to, and it's a matter of his story, which nationalities and cultures enslaved who. So to make sure that we're not dealing with a silent issue of a system of slavery instead of a quasi-criminal offense, we want the name and nationality of everyone else. Because once again, where this plays in and what you have to be thinking about and conscious of is if we already did a Rule 5.1 constitutional challenge showing that there is no constitutionality to this statute, there's no injured party, there's no proper accuser, you're forcing the man into the contract, you're forcing him into suretyship in violation of ecclesiastical, spiritual law and everything else, then it just might be that we're dealing with slavery. Our nationality, if you're a more an indigenous person, is a matter of the record, if you're putting that on the record. So in the midst of discovery, we should ask for the name and the nationality of everyone else, right? See where that's going? Nobody wants to sit there and contend with you of whether or not they're practicing in a slave trade, especially if they are. Guilty people don't usually want to be anywhere near talking or confessing their wrongdoings. But anyways, we weren't really going to go through all this. I just kind of opened it up just to kind of give you an idea. This strategy is designed to put pressure on them because they only want to deal with the one matter, the quasi-fake criminal matter. They don't want to deal with the real matter at hand. These presentments are helping you deal with the real matter at hand. So all these things you ask for, you're entitled to them. Whether they give them to you or not, it's neither here nor there. What you really want to do is expose the fraud on the record. Another thing about that on the record, now I didn't really get to this part yet, eventually I will, but to do this right here, everything on here, your constitutional challenge, your powers of appointment, if you're going to discharge something under the Trading with the Enemy Act or the Public Law 7310, your powers of appointment document, everything should be done via notary presentment. You have to understand notary presentment. You have to understand administrative procedure. And I keep speaking to people and they say, yeah, I understand it. And I'm surprised that most people don't. So I'm going to talk about a little bit of that. If you go on the website right here, if you haven't watched this yet, you need to click administrative. It says administrative procedure. This is where you want to be. Administrative procedure. There's some documents and some templates. And this is everybody. You don't even have to be a premium member. If you're new to this, you will not get anywhere far. This is a foundation. You have to know administrative procedure. And I'm going to explain a little bit of that in 1 second. So let's go ahead and kind of get into the subject matter. So we were talking about the commercial crime matrix. And what I really wanted to talk about here was, we just kind of looked at briefly the discovery, but I wanted to deal with step 5. And it says public record request for police. That's just like maybe you want a police officer's badge number, the police report. This is a template public records request, which would be like a Freedom of Information Act request or whatever they call it in your state. This is a request for that. Here's and I'm not going to click on these because let's click on them, but we got to go to the right part of the site so I can click on them. All right, so look at these requests, and what I want to call this is follow the money, right? That's probably what I'll name this video, discovery and follow the money, because this is another area where you're putting pressure on them to get rid of the matter, to not proceed any further. They don't want to open up these things. So when you go on your path to follow the money, I had a little note thing here. These are some of the things you want to ask for. Oath of office. Why do you want to ask for it? So if you're asking for the oath of office, you need to start reading Article 9 of the UCC, understand how that written oath of office to the public and your acceptance on it constitutes a security agreement, because now we're talking about the money. Now we're talking about that security agreement and the collateral interest that you have in the insurance policy supporting it. So we're asking for these things, the oath of office and the insurance policy. These are somewhat to protect your constitutional rights on this end. So you want to ask for these. But remember, when you're on the land, you have rights. So also, before doing all of this, before doing everything that we're talking about here, I'm not saying that it has to be done, but it's more powerful if you've already done several things to correct your status, to establish as a matter of fact what the status is of you as a living man, and the status of your estate, and the status of your trust, and the status of your person. But let's not really get off the subject. I just kind of want to show you the flow of we're following the money, because these are the ways that you put pressure on them. There's a thing on the website. You can find it right under here. You have to read this. Request for county payments to judge. From my understanding and from the gentleman's understanding who presents this, if the county is the one that's trying to prosecute you so they can create municipal bonds and different things that they do to create money, and the judge is getting paid from the county, then that's a clear conflict of interest. He's supposed to be getting paid from the state. So this document right here is something like a FOIA request that uses those type of requests for information laws, and it deals with the county auditor, and you can start extracting specific information to show that these judges are getting paid from the county, which may be grounds of why they may not be why they might not be protecting your constitutional rights. And that's why at the end of the day, when we're doing all this stuff, again, why we're doing notary presentment is not because we want them to honor it. It's because of what the power of a certificate of service is. I'm going to show you one in a second, and I'm going to explain it to you. And then hopefully all the really intelligent people on this list will better understand, I see how he's using these to create the estoppel. Now, I want to show you the power of the notary presentment and why we use it. I just want to kind of give you a better idea and an understanding of that. But again, even what I'm about to say here briefly is not enough for you to completely understand. I highly suggest you go up here and watch this administrative procedure video. And also another thing that just dawned on me that I wanted to mention in our whole process of following the money, where the transaction is, you also know when you study estate and trust law, one, that all courts are operating under probate, so they're probating your estate to create funds and money. But in order to remove assets or liquidity from the estate, the claimant or the person making the claim has to produce a bond. And Title 26 of the IRS Code talks about the bond that they have to produce to pay out federal taxes before they can proceed. So and there's a video up here. It's by Brother Yashu, and he talks about asking them to produce the bond. So this is something you want to incorporate with your Freedom of Information Act request. You also want the production of the 1099 information returns and the production of the 1040 or the 706 estate form. You want to ask for all of these items because why? One, we're proving that this is not law, that they're involved in commerce. Right? They're involved in commerce, and if they don't have a statute, a contract with you, they have to let that go. But anyways, let me show you something really quick. This is affidavit of particulars, a charging instrument. Now, I kind of wrote this out as a cross claim, but this can very well also be constructed as a private administrative process that can end up with a true bill or a charging instrument or a bill of particulars, which leads you into the avenue of doing a commercial lien. Now, me personally, that's my angle. That's the angle where I'm ultimately going. If I go through all of these steps and I don't get a favorable result, or they want to keep pursuing the slave trade, I'm going commercial lien to try to liquidate this person with every inch of resource of thought and intelligence that's in this mind right here. I'm going to latch on them like a pit bull and try to liquidate them. That's not for everyone. You may want to bring your cross-claim or counterclaim in court. There's so many different ways that you can deal with these things. This is just a resource. But I only say that because I know when I open this document, it is presented like a court document, but my objective is when I'm doing this, I would be really doing this privately. But what I wanted you to look at here is just some of the charges. Perjury. These are the charges that we want to bring against these rogue officials if they don't want to drop the quasi-criminal complaint. These are the reasons why we are using the notary presentment and these certain requests and inquiries for information, the things that we know they're required to give us, because in their default, in their consistent, willing default, we'll be able to prove as a matter of record, if we utilize our notary presentments the correct way, that they have committed a host of these items right here. We'll have an administrative record proving it, which is the foundational support that we want to introduce into the matter under judicial notice. We want to get it admitted into the evidence that they violated all of these. Now, again, if you watch the video of judicial notice, you're going to understand how using the notary makes these things public records that the court must take judicial notice of. Right? So anyway, you see perjury, which is lying under the record, subornation of perjury, a whole bunch of different types, false swearing, making false statements, obstruction of justice, perjury. There's other ones, I don't even know if I've added them in here, concealing the public records, a whole bunch of misdemeanors. I will add them in here in time. Obstructing of justice and witness tampering, conspiracy to defraud the United States, for example, when they're not producing the bonds that they have to produce for the tax liability. All right, so here is an example. Now, this example deals with the rescission of signature. Don't get wrapped up in the document. It's not talking about a criminal matter, but I just want to express to you how powerful the notary presentment is. Say, for an example, I was contending in court that some action was invalid because I had a rescission of signature. If I was to bring this document in court, to some extent it would be considered hearsay. It wouldn't be an exception to the hearsay rule just because it has a notary seal on it, but there is no proof that this document has been presented to another party for evaluation. There's no proof there. I guess the way to say it is this document has not been proved. This document has not been authenticated. So it has went through no process. It has went through no procedure. So it's basically just hearsay. I just came up and said it, right? It has a little bit of I don't know what you call it, but this gives it maybe a tiny bit of credibility. There's a registered mail number bonded in there where you can maybe punch that in and see, okay, there was a document delivered to a recipient, but you really can't tell what that document was. So there's still areas of hearsay. So basically what I'm saying, if I was trying to use this record in court, I might can get it recorded into the record just because I signed it and it has a notary seal on it, but it still would pretty much be hearsay because there's no evidence that this document has been proved or authenticated. You can look at what those terms mean. And the way that you prove and authenticate it is your use of your notary presentment. What a notary presentment is this, and you can do this with any document, any request. What you're doing is using the notary because they have a seal and they're an officer of the state. And when you authenticate their record at the Secretary of State, that becomes an official document from an officer of the state, a constitutional officer. It has to be given the full faith and credit of the United States, right? So this is how you're proving the document. This is a presentment. So say if I was rescinding my signature and I was going to let the attorney of the bank know, I would contact my notary and say, hey, I need you to do this for me. Let me read through it so you can see what's being said. This is the notary speaking to the attorney. The attorney gets this envelope in the mail. It has a registered mail number on it. The same registered mail number that's up here, that's on the document. And he opens it up. The first page he sees is a letter from the notary. It says, Dear John Aldridge, I have been appointed by Crimin-AL Texley, the executive for the estate trust of Texley Masson, hereinafter the principal, for the purpose of presenting records of an international transaction under notary seal in regards to the above referenced matter, that matter being the case right here. The principal, which is Tex, requests I mention that you may rebut the statements in the presumptions by executing a verified response under penalty of perjury no later than 30 days from the postmark receipt of this notice. That's all I'm going to read with that. But basically, this is the proving process. You have 30 days to authenticate this record by remaining silent, basically, or you can challenge it, or you can rebut it with your own presumptions. But this is the proving process, because after the 30 days, the notary is going to issue a certificate back to you that there was no response, and these certificates is the evidence that you can authenticate and bring into the court. But let's go through the flow of it. So you do that, 30 days doesn't, now this is the other important thing, right? This goes back to the thing where people say they're not going to acknowledge or answer those documents in court. Your most powerful document is your certificate of service. Whatever you present to another party or to a public official must be ledgered on this certificate of service. This is not for them. This is for you. This is for your indemnification. This is for your proof. This is your proof of process. This is what makes what you do a foreign judgment or a foreign act of state, right? So this is the most important document. This is what you would keep in your possession. You always have the original of this. This is an exception. Going back to our original scenario, if I bring this into the court, it's just hearsay. If I bring this into the court, I have what? A third party witness, right? It says it is hereby certified, meaning this act already occurred and is certified by a third party. This goes into the ecclesiastical law where there's two, right? Two is a witness that their claim is solid. So it is hereby certified that on this date, the notary public mailed to the attorney, John whoever, hereinafter recipient, the following instruments pertaining to Texley Masson's case. And this is going to explain each instrument as a matter of fact. So now, if you've presented something to the clerk to be recorded in the record, and it's not in the record, and you're looking in there, you have this document right in your hand, a certificate of service. This is the incriminating, indicting evidence right here. Right? It says the instrument. Listen, it describes the instrument. So it's important that you describe the instrument with specificity. Right? The instrument is entitled a rescission of signature from the loan note referencing the deed book, etc., signed and dated on this date by Tex Masson, addressed to John whoever. How can he say that he never received that? Right? You have a notary certificate of service. It's going to have the seal on it. You can take this all the way up to the Secretary of State and authenticate it. These, when you look at this type of record and you read back in what can be accepted as judicial notice, this kills the presumption. This is the proving process. The last thing that we didn't discuss is after. This is what the notary will issue you the day that this is mailed out. After the 30 days, the notary will issue a certificate certifying that this person didn't respond. The certificate of service, which is the proof of notice, or the proof of it being sent, and the certificate of non-response certifies evidence. That's proving your process. That's why it doesn't really matter whether they accept it or not. We are trying to get them to shut down these proceedings. This is an interjection. I also wanted to say, the certificates and the non-response, those certify evidence, but it's this evidence that you want to use in your cross-claim or your counterclaim, right? So you have to put these pieces together, and maybe this will better help you understand what we're trying to build with the commercial crime matrix. See, evidence that you produced records that needed to be recorded and that the records were concealed. Those are consistent with perjury, misprision, felony, and some other violations that I'm going to put in here that's not in here just yet. So I hope that kind of makes sense. Just wanted to interject that part. Nobody wants to be tied up in fraud. That's what we're going to create. But anyways, when we follow the money, we want to request to the county. We want to see what's in this judge's pockets. What is he, where is he getting paid from? Why is he getting paid from the county? The same one who's trying to bring a fake criminal action with what? And I keep saying this in every video. No injured party, no proper accuser withstanding, right? No corpus delicti. Why is he doing that? It's because he's probably a pirate trying to create money using his position to benefit, right? What is that? And that's what violation of legal code, violation of trading with the enemy act. It's a violation of a whole bunch of things. Violation of the oath of office. It's everything that we're proving on the record is taking us right down here to the charging instrument, right? The affidavit, the bill of particulars, the charging instrument, where we're going to be talking about misprision of treason, misprision of felony, concealing the public record, refusing, all kind of things. We're not going to open it up right now. So we're still in a follow the money. This is another document right here. This is how you request the oaths and the insurance policies for the state, the county, the judge, or whoever. All these templates allows you. Now I put these in discovery, but these templates you're going to be sending under the Freedom of Information Act, Freedom of Information Law, and your state law, and all of that. I recently found something else, which is also. Let me see if I put the link in here. Yes. So you can follow this link right here, but basically you can go into CFR, the code of I think that's Code of Federal Regulations or something like that, and this lets you know that there's a financial disclosure statement, and you can find this on the state level too, when your judges and legislative and executive officers are required to disclose their finances. It's a matter of public record. So you want to start getting this stuff and digging into this stuff and doing some research on these people that's trying to liquidate or administer claims against your estate. Right? You want to find out who they are, because ultimately, I know right now everybody's worried about trying to keep their house and trying to keep this and trying to get that, but really our mind has to start shifting, because really what we're supposed to be doing, it ain't a matter of trying to keep, it's a matter of trying to find out who's corrupt, who's not, how to remove them, how to get them out of office, right? Enforcing the Constitution. That's what we, the people, are supposed to be doing, right? Especially Moors, right? That's the mandate that Noble Drew Ali gave. All right, so we kind of follow the money again. All of these things, because where are we going with this? We're trying to prove that what's taking place is not constitutional. It doesn't have anything to do with crime. It has everything to do with slavery, and the reason why we're asking to see the money and all of this type of stuff, there's so many other things we can ask for. We can, and this is what I encourage you guys to do because it's what I intend to do. I'm always doing this type of stuff, but we have to start formulating these FOIA and Freedom of Information Act requests. Start asking, inquiring to the Securities Exchange Commission, to the Department of Commerce of your state, to the Administrative Office of the Court, because we have to start finding out all the specifics about how these cases are being securitized and monetized. Because those are assets that, one, you need to redeem, and those are also facts that you need to use to protect yourself from these quasi-fake criminal proceedings. Right? So I hope you guys see what we're doing is we're putting together something. You're not going to get it all in one video. But if you start watching all these videos and putting the pieces together, you will be in a more powerful place to deal with these things and to help other people. So this little link right here, let's click it real quick. Okay, we're going to click it, see what it is. I think I remember what it is. Okay, see, here's an example, and there's other forms. This is OGE Form 450. There's some other forms over here, some FAQs. It's called Public Financial Disclosure. The purpose of this report is to assist employees and their agencies in avoiding conflicts between official duties and private financial interests or affiliations, right? This taps right into what we're trying to establish to get an estoppel in this matter, or to have a ready-made counterclaim for a whole bunch of things. All right, let's see. Oh, okay, where's my little note? I was just on a notepad. Okay, this. Did I cover everything? And by the way, all these Freedom of Information Act templates and all these things that I've been talking about, visit thctrust.org. Most of those templates you can get for free. Some of the things we discussed in here are reserved for premium members. By the way, I really need you guys' support. It's only $25 a month. That's less than $7 a week. And we're kicking out some knowledge and some resources over here. So, please help and assist our organization so we can continue moving forward with our goals and objectives, which is, we're talking about the criminal matters now because we're moving closer and closer and slowly bringing the research so that we can really adequately start formatting these teams and helping get people out of this prison industrial complex. All right, so now here's another important thing, because we're talking about leverage, basically. And I'm saying leverage because we're dealing with public officials, their insurance policies, and following the money trail when they're trying to administer claims on our estate. Other things we want to start, Freedom of Information Act, is the Judicial Code of Ethics, or I forget what they call it, but just Google Code of Ethics, so then you can see, how the judges are supposed to, what they're supposed to be doing. All these things, we want to know more about their position and their jobs than they know for themselves. We're coming in as enforcers, as third-party interveners, especially when we have to launch or launch a counterclaim. Immunity. So when you follow these sites right here, I put these 3 sites at the top. These are just links to other powerful resources. These resources are full of case laws that are going to show you how they waive their immunity. It's going to show you time and time again how much immunity that they don't have. But not only that, and these are so many good case laws. Like, let's go here right quick. This is more corpus delicti. For a crime to exist, there must be an injured party. With no injured party, a complaint is invalid on its face. Supreme Courts have ruled without corpus delicti, there can be no crime. In every prosecution, for it's necessary to establish corpus delicti, the body or the elements of the crime. In every criminal trial, the prosecution must prove corpus delicti, or the body of the crime itself, the fact of injury, loss, or harm, the existence of criminal agency as its cause. That's not what I was going to, but that's good. We were looking for the laws showing that these public officials do not have any type of immunity. So here's some other excellent case laws. Look at this. The phrase Court of the United States without more means solely courts created by Congress under Article 3 of the Constitution and not territorial courts. Here's a case law supporting that. Look at that. That's pretty fly, right? United States district courts have only such jurisdiction as is conferred by an act of Congress under the Constitution. United States Code annotated Constitution, Article 3, Section 2, whatever. So these are some excellent case laws, right? Again, use these somewhere. You'll use them somewhere if you have a quasi-criminal matter, you're challenging jurisdiction, things like that. Man, there's some seriously good resources in here. I suggest you use them. Let's read another one. In a criminal proceeding, lack of subject matter jurisdiction cannot be waived and may be asserted at any time by a collateral attack. Listen to that, right? In a criminal proceeding, lack of subject matter jurisdiction cannot be waived and may be asserted at any time by collateral attack. We are preparing and setting up a collateral attack, okay? So now, let's see. The United States District Court has only such jurisdiction as Congress confers. Hey, you hear that? So challenge the jurisdiction and demand to see proof that Congress has conferred the matter to the United States District Court for jurisdiction. All right. Now, we still didn't get the document that I wanted to bring up, and we're gonna get to it. This must be the one. This must be the one. Or is this the one? Let's get that crap out of here. Okay, here we go. Let's look up a word search for immunity. All right. When a judge knows that he lacks jurisdiction or acts in the face of clearly valid statutes expressly depriving him of jurisdiction, judicial immunity is lost. Here you go. That's a case law. Loss of immunity. No immunity. Here's a whole bunch of case laws right here. So follow this link. Sovereign immunity does not apply where, as here, government is a lawbreaker or jurisdiction is the issue. You see that? Another case law. An officer may be held liable in damages to any person injured in the consequences of a breach of any of his duties connected with his office. The liability of nonfeasance, misfeasance, and malfeasance. Probably saying that wrong. Okay, knowing, and there's your citation down there. Knowing failure to disclose material, this is important. This is the presumption of what we're building towards our cross-claim if it has to go that far. Knowing failure to disclose material information necessary to prevent statement, knowing failure to disclose material information necessary to prevent statement from being misleading or making representation despite knowledge that it has no reasonable basis in fact are actionable as fraud under law. That's powerful. Here's another one. Party in interest may become liable for fraud by mere silent acquiescence and partaking of the benefits of fraud. That means you can't remain silent when there's a duty to speak. You may want to take this statute and add it to your Rule 5.1 constitutional challenge, because when you're challenging the constitutionality of a quasi-criminal statute that has not been enacted into positive law, and when there is no injured party, the Rule 5.1 says the Attorney General may or may not respond. But on the contrary, when they have a duty to respond, because remaining silent would be participating in the silent fraud, that changes the circumstances. So you may want to express the Attorney General's duty and obligation to respond based off the fact that it involves her constitutional rights, based off the fact that her silence would be deemed and would rightfully be deemed participation in the silent fraud of slavery, because the whole municipal agency is benefiting off of it. Right? Hope that makes sense. I hope I'm not just, let me know. If I'm just talking and nobody's really grasping and catching on to what I say, let me know. I know I'm kind of talking fast. Still, let me know. But the good thing is you can rewind this video and let it sink in and marinate more. So those are the statutes removing the immunity. But even more important than that, we got the Vatican letter, right? Where Pope Pontiff Francis has been running around removing these people's immunity. And once again, all of this, what we're doing, right? All of this is dealing with, what I want you to understand is how all of this plays into your affidavit of judicial notice, or your request, or your demand or request for judicial notice, however you're going to do it, because all of these records, right? Those records and everything under the criminal matrix, when we start doing these notary presentments, all of these are going to be admissible. I'm not going to say they're admissible, because that's a determination that the judge may or may not try to block you with. but you can make the court take judicial notice of all of these things, right? And these are the things necessary to set us up for our counterclaim and our cross-claim. So I hope you enjoyed this video. I hope you would also join our website, www.thctrust.org. And again, all of the templates that we mentioned as far as the Freedom of Information Act requests and the notary presentments, certificates of service, those are on the website. So make sure you visit, create a free account, and within the first week, check your email. You'll be receiving an email invite from us to join the email list. Make sure you do that. Make sure you also share this video with someone else. Feel free to download our information. I've been having a couple of hacks and attempts to compromise the website, so consequently we're now going to start implementing the cloud technology. And for those who don't know, I'm a technology major, graduated from the University of Maryland, degree in computer studies. I worked on firewalls, routers, switches in the Marine Corps, and I'm starting to kind of think more how I can use my experience with technology to better assist our situation. So I'm thinking about that, and I'm all about combining resources with groups, doing things. I'm about conference calls, lectures, not so much lectures, but more like workshops, specifically meeting face-to-face with groups. I'm actually going to put things more in an automated, I'm going to make things online more automated, and I'm going to start taking more opportunity to get out and sit with people personally and get things done. Of course, that costs resources, but at the same time, I want to do that because that's going to allow me to meet people in a face-to-face, combine forces, and build. So again, visit the website, support our organization. $24 a month is less than $7 a week. And at the same time, if you can't afford it, there's still a lot of free resources on the website to get you in a position that you can afford to support us. Thank you again.